There are two terms that we find in Quebec law relating to custody and parental time. What we see usually is the term custody and access time will be used for common law partners, and parental time is a relatively new term that we use for spouses. They basically mean the same thing. And, the definition, the Civil Code of Quebec doesn't define it, what custody and access time means. But in practice, we understand it to mean the time that the children are under the care of either parent. So the terms that we usually find are custody, full custody, shared custody, access rights, prolonged access rights. And how we define them is really with regards to kind of the percentage of time that the children spend with the parents. So full custody will usually mean if the children are under the care of either parent for more than 60% of the time. Shared custody, we're talking about 40 to 60%. And access rights, we're talking about anything below 40% of the time. And these percentages will be important when we calculate the child support payable, because in Quebec, the government takes into consideration in determining the child support payable, the amount of time that children are under the care of either parent. The logic behind it is that the more time the children are under the care of either parent, the more costly it will be for that parent. So there are adjustments to be made for the child support. Regarding parental time, the concept of parental time is usually, as I mentioned, used for spouses because that's the term that's used in the Divorce Act. But really it means, the term is just different terms, but it means the same thing. Parents have the misconception that if they have full custody or the majority of the parental time or custodial time with a child, that they have the sole responsibility of making decisions or important decisions for the child, which is incorrect. Both parents have the rights and to make these major important decisions in the children's lives. So when we're talking about major decisions, we're talking about decisions relating to health, anything with regards to taking medication, specific care, having access to, experts, things like that. Usually we see these types of questions when one of the parents is seeking a diagnosis for, ADHD or things like that, or there's contestation with regards to medication. So both parents have a say in this process. Other major decisions that will warrant both parents' implication is with regards to education. So choice of school, do we send the children to French school, English school, private school? These are elements that both parents take a part in. Anything with regards to cultural, spiritual decisions, special expenses for the children. We'll also see the implication of both parents regarding decisions for travel outside the country, authorization to travel, and relocation of the children. So it's not because you have full custody or the majority of the parental time with the children that you can, pick up and relocate without both parents having a say. If the parents can't come to an agreement with regards to those major decisions, they have to seize the courts. So the courts will substitute themselves in the parental or the parents' rights and will make the decisions for the parents. So if possible, come to an agreement. If not, then the courts will decide instead of the parents. There are some instances as well where the courts will authorize one parent to make decisions or major decisions without the prior authorization of the other parent. We find they're the exceptions to the rules, but we find these types of judgments when there's presence of conjugal violence, or that the decision-making process is used as a tool to kind of hinder the other parent, or simply that a parent isn't making decisions that are in the best interest of the child. So the courts can award one parent the decision-making responsibility and without getting the prior authorization of the other parent. In some instances, obviously, taking up these matters with the courts can be costly, time-consuming, and in some instances, the Quebec government has adjusted itself with the reality of, conjugal violence. And in some instances, a parent who is victim of conjugal violence can obtain the authorization without seizing the courts for the children to receive help from therapists, social workers, psychologists without the authorization of the other parent. It's an administrative process. The parent can can make a request on the government websites. There doesn't have to be a formal complaint or police record of the complaint or criminal record in order to have access to these services. So an element to consider as well. The bigger points that the courts will consider are the parental capacities of both parents. So this means, a range of things. So, if the parents are able to care for the day-to-day needs of the children, if the parents are able to cater to the psychological needs of the children, are the parents, if there's obviously conjugal violence, that has to be taken into consideration by the courts. If there is an issue relating to, drug use, alcohol use, or any substance abuse. An important element as well that the courts will consider, and that I think parents don't necessarily take into consideration, is the courts will also, in their analysis, will look at, the custodial parent or the parent who has the main parental time. What type of access are they giving to the other parent? Because if there is always an issue with a parent being able to exercise custody or access rights and things like that, or it's always problematic, the courts might interpret it as the custodial parent or the parent who has the main parental time as being unable to put the needs of the children before their own needs, or before whatever they might be feeling towards the other parent. So that's an important element also to take into consideration, and that parties or parents don't usually think about. Regarding the best interest of the child, courts are supposed to as well take into consideration the cultural background of the children. We see those types of decisions mainly in adoption cases, where they'll want to, as much as possible, maintain the children in their communities. They'll take also a look at, the parents' relationship with the children, who the children are most comfortable with. They'll take a look at the desires of the children. So, that's another aspect, and a complicated aspect as well. The courts now have to take into consideration the desires of the children. If the desires is expressed freely, and if the children have the ability to kind of understand the consequences of the desires that are being expressed. Sometimes how this comes to play kind of in a courtroom setting is usually there will be an attorney appointed to the children. In DYP cases or cases before the Quebec court, no matter the age of the children, an attorney will always be appointed to the children. In cases in front of the Superior Court, where we're really discussing more custody cases without the intervention of the DYP, this has to be requested, and the court has to kind of analyze the situation of the children and to see where they are at in their development, to decide whether or not it's going to be pertinent to know what the desires are and if they're going to be taken into consideration, etc. So the age it depends obviously on the child, but sometimes the courts will appoint an attorney to a child as young as 8, 9 that we see. And the more we move on with age, the more the desire that is expressed will have more weight. So when we're talking about a child that is 12, it will have a significant weight. And when we're talking about a child that is 14, then, more often than not, the courts will go with the desires that are expressed by the children. Obviously, the courts have to outweigh the desires of the children with their best interest. So they won't put a child in an environment where it's unsafe or there's no, boundaries that are set. So the desires that are expressed has their limitations, but we see more and more that the courts will follow through with the desires that are expressed when really we reach the age of 14, 15, 16, then the courts will intervene a little bit less unless it's an exceptional situation. So when talking about an arrangement, I'm really referring to kind of a consent or a parental plan. And this depends on the level of dispute between the parents. So if we're in a situation where there's a high level of conflict, we'll want to have a consent or parental plan that is as detailed as possible, so as to limit the exchanges between the parents, where the exchange of the children will take place, holidays, vacations, special expenses. So we'll want to have something as detailed as possible. And usually, as when the separation is fresh, that's usually what we recommend, because emotions run high and sometimes we don't necessarily make the best decisions. As time goes on and kind of the temperature of the water kind of diminishes, then, we invite the parents to be a little bit more flexible with regards to requests that can be made by either parent. It depends on where the parents are at in their separation, conflict. Obviously, communication is key, having proper and respectful communication. A good place to start. So if the parents are already in a couples counseling or marital counseling and things like that, the best advice I could give them would be to kind of steer away from the couples counseling and fall into a separation therapy. It can be with the same professional. that already knows, the issues and things like that, or knows the couple and the family. This is the most, I would think, beneficial way to proceed, as the discussions about separation, how we announce the separation to the children, who lives where, and who relocates and things like that, what, for schooling, change of schools, things like that. These discussions will take place early on in a controlled environment. Parents will be able to work on a plan. We'll work together in the implementation of this plan, so that when clients come to see me and haven't, announced to their partner their separation or their intention to separate, this, I believe, is the best advice I give them. If that's not possible, because it's a little bit the exception, if that's not possible, there is parental coaching, which we strongly recommend. Parental coaching will really work on also the decision-making process for the separation, for the children, but will work really on communication between the parents, and can also work on establishing a plan for the children. Again, how to announce the separation to the children, etc. And as well, the parental coaches in some instances, and if the children are of age, can also ask to meet with the children. So that can be kind of a different aspect or a different perspective. When I talked about a little bit earlier of, having the desires of the children taken into consideration, a parental coach can do that without, the parents asking directly the children and putting the children on the spot. So not all parental coaches will do it, but some will. So that's an element also to consider, and to kind of question the professional that will follow you with, or follow both parents if the parental coach is open to meeting with the children. There's also mediation. So sometimes, parents get confused between the role of a parental coach and a mediator. A mediator will really try and find a solution to the separation, in the sense that they will try and find solution with regards to, custody, access time, partition of the financial interests between the parties. The role of the mediator is not really to work on the communication between both parents. The role is really to find solutions to conflicts, or, how to go about after the separation. Another important element to consider as well is that the government does cover some costs for the mediation process. So it's always a good place to start before, speaking with lawyers for contested files and things like that. It's some consultations are paid for by the government, so why not kind of take advantage of the offer. Another also element is, and people are not necessarily aware, but before, if ever we're in a contested file and we need to fix a trial date, both parents have to submit themselves, except a few exceptions. For example, conjugal violence and things like that. But parents have to submit themselves to a parental course that is given by the Superior Court of Quebec. This can be done online, but you don't have to be. It can be an interesting course to take part in, or to get information. Last resort, obviously last resort is always a contested files, but once the contested file is in place, another recourse the parties can have, it's called parental coordination. Parental coordination is usually awarded by the courts, and a social worker will be. Usually there's a judge that is appointed to a case. So we're really talking about very high conflict cases. And so a judge will be appointed to the file or to the family, as well as a social worker, and the social worker will give updates to the courts as to how the parents are doing, the progress, and the judge can make decisions or render decisions more kind of in a fast track basis to make sure that we work really on the diminishing the conflict. So this is very particular, and we don't see this in many cases. The common mistakes parents make when negotiating or drafting an agreement, I think the biggest mistake is not being informed of your rights, right? Because we're going to talk about a little bit later on how to best prepare for a negotiation process. But I think not knowing your rights, not knowing what is most important or what type of argument has more weight. I've also mentioned in a high-level conflict situation, we'll want to have something that's very detailed. Sometimes, the parents will get kind of wrapped up in that detail. We see more and more parents requesting kind of a limit on, screen time. I understand it's a concern, but sometimes these types of requests are very hard to implement, right? So how can you verify if your son has only spent 20 minutes on screen time at dad's or at mom's? And if you agree to something and you recognize that, for example, for shared custody, that the other parent has the parental capacity to have the child with them for, half the time or whatever time you decide, then you kind of accept that the parent is capable of making good decisions for the day-to-day of the children. So sometimes we get a little bit too wrapped up in the details, and some dispositions that are put into agreements are very hard to implement or very hard to kind of check to see if they're respected. And even for the courts, even if it's something that is being requested in front of the courts, and because there's a special circumstance, the courts award what you're requesting, it also makes it very difficult for the courts to verify, like I said, screen time and things like that. So, sometimes the court's capacity to verify certain elements is very limited. So I feel like sometimes the parents live some sort of disappointment with regards to what can be done in a court type of setting. So that's why, parental coaching and mediation is really important, because you will be able to have those types of conversations in a more relaxed setting. But, the other parent is in front of you and will be able to consider, what you have to say. Another element super important, and we see this I recommend this for all parents, even if it's not a high-level conflict, anything that is instant messaging, whether it be, messenger, text messaging, and things like that, especially when we're in a high-level conflict cases or situation, it's really to set aside, because, we're just responding out of reaction, and things usually take proportions that are not necessary. You're taking your attention away from the time you spent with the children. You become upset. So really anything that is instant communication with the other parent, really set that aside. Go for more traditional communication, unless there's an emergency, like for emails and things like that, where you're really going to take the time to think about your response, and you don't have to respond right away. You do have to respond, because that's a whole other issue. But something that, in very high level conflict, we also recommend, applications or even a communication booklet so that, again, there's no quick responses. So that's a major element. If there's one thing to take away from the conversation today is really, the text messaging and messenger as much as possible, set that aside. If the parent doesn't respect the agreement or a judgment, in practice, it opens the door for the other parent not to respect the agreement or the judgment. So it kind of creates chaos, and then we have nothing to revert back to. So, if you're the parent who is not respecting a judgment, take that into consideration, that you're starting kind of a chaotic situation where there's no more boundaries and no one's going to follow the judgment or agreement anymore. So that's a possibility. If there's a judgment, we can file procedures to have the other party in contempt of court. We can have the agreement or judgment reopened. And, depending on the gravity of what is being not followed with regards to the judgment or agreement or whatnot, then this can impact custodial time or parental time. But like I said, in practice, what we see is, once the judgment is set aside by either parent or is not being respected, then both parents will pick and choose what they respect. And then, we come to a situation where it's a little bit chaotic for the parents, for the children, and, more likely than not, they'll end up in court to have a little bit more stability put back in place. The courts obviously will want proof, and usually how that is, the courts will give a lot of weight or more weight to psychosocial expertise where there is a diagnosis. Usually in these types of cases, there'll have to be a lot of, a third-party testimonies, for example, from, teachers, social workers, or the parents themselves that explain kind of the children's reaction or the other parent's actions. So these are very difficult cases. Courts do pay a lot of attention to them. Usually what we see in the psychosocial expertises to kind of counter the alienation is more often than not, we'll see that the experts recommend shared custody to kind of rebalance. And in these types of cases, the desires expressed by the children will have less weight because the courts will consider that the desires expressed aren't, expressed freely or clearly. It's appropriate when there's a significant modification or significant changes in the situation of both parents or either parent or a situation of the child. There's no specific definition of, what a significant change can be, but sometimes, when there's a judgment or there's an agreement when the child is 2 years old and now the child is 10, the passing of time is a significant change because the needs of the child are not the same. Their reality isn't the same. We see that the courts will obviously reopen the file when there's a question of relocation. Again, when the needs of the children change. And sometimes as well, when the children have been in a shared custody type of arrangement for a certain amount of time and, it's not working. or when the desires of the children are expressed to put an end to shared custody or to spend more time with either parent. So those are significant changes that the courts will take into consideration, but there's no specific definition. It's on a case-by-case basis. How to best prepare a negotiation with another parent, whether, represented by an attorney or not. I think the number one thing is to be well informed of your rights, the rights of the other parent, the rights of the children, because this makes for a more fruitful discussion session where, when you're requesting something and, the courts would never award such a request, it puts kind of perspective on what you're requesting and what's most important. As well, it enables you to make informed decision with regards to what the other parent is requesting. It will give you confidence in the negotiation process as well if you have more knowledge on what the courts would usually award and things like that. And you might be less influenced by whatever the other parent is saying. Another good recommendation would be to make a list of what it is that you want, and to put kind of a star between or beside what is most important to you and what you're ready to make concessions on, to fix your priorities and to know where there's wiggle room and there's absolutely no wiggle room. I think that's the best way to prepare. Like I said, be informed, have your documents in order, and have a plan. Have a plan as to what needs to be discussed and what should be discussed first. Documents from third neutral parties. I mentioned before, psychosocial expertise, teachers' letters, or third parties who have witnessed a situation. That will have weight because it's coming from someone who's neutral in the children's lives or in the parents' lives. As well, we use a lot of exchange of text messages or, messenger. So that's why I'm telling you that, if you could steer away from that as much as possible, because whatever you write to the other parent will most likely than not end up in court. Writings have a lot of weight. Testimonies, again, from, clear, prepared testimonies, as well as, testimonies from third neutral parties and, testimonies from people who can corroborate what you're mentioning. So those elements are important. Also, yes, I mentioned, that the children can be represented by attorneys. Usually the attorneys will write reports on, what the desires are. They'll write, good reports will kind of give an overview of how the children were met, how the process went with the attorney, how long they met for, which parent drove the children to the meeting, if it was an in-person meeting or a virtual meeting. But, a very detailed report from the attorney to the children will also have its weight. Again, no instant messaging, so I can't stress that enough. I think that, if you can obtain the help of, a third party like a social worker, a therapist, and even if it's in a high-level conflict and the problematic parent is the other parent, you can only control how you react to things. Usually those professionals will give you good advice on how to maneuver conflictual situations. Will give you advice on how you interact with the children, how you explain the situation or the reaction of the other parent. So I think that's very helpful. Obviously, two mature parents who can properly communicate is the best, but that's not always the case when emotions run high. Whatever you say in front of the children or how you act in front of the children kind of sets the tone for what your children will find as being normal communication. And how it impacts the children. So more and more we see in high-level conflict cases, I would say in recent years, that the children have really strong reactions. And more the children are helped by social workers and psychologists, but be aware that you're putting your children in a difficult situation. The last thing I would say is, if you can come to an agreement between parents, and through all the means that I've mentioned, so mediation, parental coaching, separation therapy, if you can come to an agreement, because you have to be reminded that when you go to court, and sometimes you have no choice, right? But when you go to court, you're in front of a judge who doesn't know necessarily your history, who hasn't met your children necessarily. Sometimes they will meet the children, but it's quite exceptional. And they will render and even the judge will say they'll render a decision on what's in front of them that day. So if your testimony doesn't go very well that day, or if you forgot to file some exhibits, the judge can only render a decision on what's in front of them, and without necessarily knowing the whole family context. So if you can come to an agreement, that's the best, because if you go to court, then it's a third party. You kind of remit control of your family dynamics to someone who doesn't know you. So, like I said, sometimes it's not possible and we have to go to court. But if you can come to an agreement, there are a lot of resources out there. Please do. Parents want to self-represent, and it is quite tricky going to court. There's all sorts of rules that have to be followed, delays, documents that have to be deposited within a certain time frame. There are all types of organizations that can help prepare you for court, that can help you in the preparation of, drafting procedures and things like that. The first element that comes to mind is le Centre de Justice de Proximité. There is also Justice Pro Bono, which is Porte 33, who gives free consultation with a social worker, with a lawyer and a social worker in the actual courthouse. And you have to be informed ahead of time because they're not there every day. But there's a program called the SAGE where you can have access to an attorney day of. So if you have a court date day of, it's a little bit late and last minute, but if you want to have legal information, you can have access. Again, I don't think all courthouses have this program, but many of them in the bigger Montreal area have those. If you can, just get one consultation, just an hour consultation. It will be money well spent with an attorney so that they can explain the specifics with just, filing procedures, the delays, what has to be respected, because you have to be aware that there are different rules that apply, or rules do change from one courthouse to the other. So, a parent who is presenting a motion in Laval or in Montreal won't necessarily be subject to the exact same rules as a parent presenting a motion in Longueuil. So you have, it's tricky even for lawyers to kind of see, you know, what rules apply to what courthouses. You do have on the Superior Court website, you have the rules for Superior Court for the Court of Quebec available on their website. It's very long. There is a section for family matters, but they will tell you, you know, when you have to file your motions, the delays. Sometimes they have some examples as well on their websites. So those are good elements to take a look at. But it is, I won't lie, it is a kind of tricky to kind of, you know, find yourself in all of this sea of information. So like I said, you know, if you could get just a small consultation just to be guided. And as well, you know, even though you are self-represented, and that's where it gets a little bit trickier, is if you decide to represent yourself, you are subject to the same rules as, you know, the opposing counsel. So everyone, even though you choose not to be represented by a lawyer, the same rules apply to everyone. So you might not necessarily catch a break because you decide to represent yourself. So more often than not, what we see is, you know, files where a person is self-represented. Sometimes the files will be postponed because the file isn't in order, or requests will be rejected. So it's really important that you get the information ahead of time if possible. But you have resources. It's just kind of taking the time to getting the information.